And morning, monsters. It's still boiling hot. So, today we are actually going to talk about something I hadn't planned for today. I planned something different, but after conversations that came up, I was like, you know what? I've spoken about this in disparate parts before, but I'm going to actually just tackle it this morning because I think it really does need tackling, and that is fan art and IP legality. I'm just going to say IP legal there. So, this is a real hot button topic for a lot of people. Now, huge ass disclaimer, I am not a lawyer. That being said, I have worked with a lot of IP lawyers. I have exposed myself to a lot of this. I have friends who go deep pretty on this, but I am not a lawyer, and this is not legal advice. And now that wonderful tissue paper disclaimer is in place, first of all, we need to talk about intellectual property, why intellectual property exists, and sort of the foundation of the system. However, before we dive into the legality, there's something I want to get off my chest that discloses my personal viewpoint on this, because I think it's important to know someone's biases when they're giving you advice on this kind of stuff. So my very strong bias comes from the point of view as I think our current IP laws are broken, and I think it goes against the tradition that has allowed humanity to grow through its oral history. So the short version is, if you go back to sort of Greek gods, and you go back to, things like Zeus, right? Zeus is like the original Spider-Man, basically. Shit tons of stories have been told about him. If you go back to Greek theatre, the amount of plays that were stealing content from each other and riffing off stuff. Similar thing happened with Shakespeare. Whole plays got lifted. Throughout history with oral tales and legends and fairy tales and myths that you've heard of, there's been so many retellings and reimaginings that that is how we've evolved the artistry of a story, and that's why so many of these characters and let's just call them proper nouns, have sort of survived for as long as they have, even to being remade in modern Hollywood. And I think that's healthy, and I think that's good, and I think we should strive for that culture. So that's my personal bias disclosed. So that's my bias, right? Okay, so let us talk about fan art and legality of fan art. First of all, what you think is legal is probably not legal. There's a huge mishmash here. So how it basically works is we started providing copyright protection and IP protection. So there's IP, there's copyright, and then there's trademark, and then there's patents. These are disparate things, but they're all sort of in the same pool. Basically, what happened with most of these is we got a situation where everyone agreed we need to advance science, we needed to advance literature, we need to advance a bunch of stuff. And then what was happening was people were saying that given inventions like the printing press, given sort of global trade, as trade sort of expanded out and became more of a thing, we needed to incentivize people to make stuff, because the public domain was suffering because people weren't making stuff, or people were not releasing stuff, in theory, because of a fear of it being stolen. And so there was a lot of, especially around patents, there was a lot of secrecy happening around mechanical invention, right? So the classic thing is guilds and tradesmen would have a new technique of carpentry or a new way of extracting a mineral or something, and they wouldn't tell anyone because they were afraid that once they told someone their trade secret, which is really what a patent originally was, a trade secret, would lose value, and they as a tradesperson would be unable to trade on that. But then it got expanded out into these areas here: trademark, copyright, and IP. Now, starting up from the bottom, patents were meant to protect inventions, primarily inventions. So for the longest time, patents, you had to have physical proof of your technique or your physical invention. They got expanded over time, but the basic idea of patents was to get people to share their techniques publicly, right? So someone would invent a new lathe or a new machine, they would get a patent on it. It would they'd be able to use it, but the knowledge would be able to get spread. The academics would be able to work on the principles and concepts applied, and would be able to move science and society forward. And then the patent would eventually expire after a reasonable amount of time, and the knowledge would revert to the public domain system of patents. Now, patents have a very strong exception that you cannot discover a patent. Now, this gets really mucky because lawyers have basically fucked us in this area, but the general principle, this is why fashion cannot be patented, because it's too utilitarian. Additionally, this is why maths can't be patented, because in theory all maths exists and you are just discovering a theorem or a proof. But then ironically, software patents are patenting math, and there's some really dodgy stuff around there. But yeah, the idea behind patent is an invention. Very little in the world of computer games and comics is ever patented. In theory, you could patent a printing technique or a particular, now with software patents, you could in theory patent like a method that Photoshop used or something like that. But to your average ordinary creator, patents don't really apply. We're kind of chill with patents. I think there's definitely some reform to go on around patents. One of the few places that patents have actually hit video game developers is loading screen mini games. So this was never properly challenged in court, like most patents, because most patents are never actually challenged. They're just issued and then paid off, because legal system sucks, especially in the US. Oh yeah, big note that sort of forms this. US legal system is one of the few legal systems, there are others in the world, where if I defend myself, I end up spending money. So for instance, in the UK, if someone takes you to court, for most cases, there's exceptions and complexities, but if you try to sue me and I have to hire a lawyer to defend myself and I win, you pay for my lawyer, right? So if I believe my case is sound, I have perfect reason to go ahead. Whereas under the US system, my defense is not recoupable in the payment and the final payment. So issues around there. Oh yeah, and most of these came around with America and expansionism. Trademarks, very simple. Trademarks is basically the little TM symbol. You have to apply for a trademark. A trademark is basically saying, I made this thing, and it is sort of a stamp. So traditionally trademarks were blacksmith marks and leatherworking marks and things like that. Trademarks are very simple and uncontroversial. I don't think anyone is upset with trademarks. Potentially the only issue around trademarks is to protect your trademark legally, you have to challenge any misuse of your trademark. So for instance, if I have a trademark on XCOM, right? Anytime anyone made a comic or anything using the format of my trademark, and trademarks are very, very specific. So you can't trademark something that would ever be in common usage. There has been some cases where people have trademarked colors, but they generally won't trademark a color anymore. They'll only trademark a color in combination with something else. So Coca-Cola Red is trademarked under very specific circumstances, but not the color itself. But basically it's saying, this is a thing that identifies my product. And for instance, if I make a knockoff dress, because fashion is not patentable, it's not protected, my knockoff is fine until I put the little mark of whatever fashion house I'm ripping off. Now again, if I alter that mark in any way, so instead of XCOM, if I go, I don't know, if I go YCOM, it'll be fine. But for instance, if I go like the mathematical X, the curly X, they'll say, oh no, that's too close, that it could confuse a consumer. But your trademark is automatically lost if you don't defend it. So even if you're a small company, legally you have to fight and defend for your trademark. This is probably the one that upsets people the most, because under current laws, if I'm someone who makes, let's say I'm someone who makes Lego, and someone is making a bunch of Lego promotional content in a certain way that I like and I want to support, there's no way for me to allow them to use the name Lego without a formal licensing agreement. I actually have to stop them using it, and I have to sue, and I do have to do a cease and desist to protect the trademark that they are using there. And then we get to copyright and IP. So traditionally, most of these laws that we're talking about have been at a national level, right? Here's the fucked up thing about all of this. It was not voted on in most countries. One of the countries that had the strictest laws is USA. And this is largely because of the large geographic size of USA. There's a history of conmen and swindlers and traveling traders and stuff that, because USA was land of opportunity and all that stuff. And also, frankly, modern marketing got invented in the USA. And marketing really feeds into this whole discussion. So, intellectual property and copyright, they get muddled a bunch, but the short version is, if I make a character like Spider-Man, that is IP, right? If, however, I make a specific comic featuring Spider-Man, that is copyright. Now, traditionally, when we started most of these laws, copyright was what we focused on, right? So copyright was basically someone made a book and they didn't want other people to copy the exact words in that book and publish it elsewhere. And that was very simple, and everyone generally agreed with that. However, it was also very, very limited. In most places, it was limited to 10, 20, 30 years, it was quite constrained. Over time, it did get expanded, but we'll get to like one of the worst expansions of that. But we're going to summarize this very, very briefly. This is not a history on copyright. I'm just trying to explain where the angles have come from. But intellectual property started getting thrown in with copyright in cases where people were taking well-established characters that have been marketed or used in works of fiction, or they had taken things that basically had been marketed quite heavily, had been used as part of the brand identity and all that stuff, and we're reusing them in other places. And that's where intellectual property comes in, right? So there's also trade IP. Can also cover patents and trade secrets as well, but now we're sort of getting broad, and I really want to focus in on how fan art and creators overlap with this. Starting to cool down to that nice place. So remember, huge rash reminder, the entire purpose of this was to take things, encourage creators to make things and share them. It started off with trade secrets, but it was also intentionally to get people to publish works, and it was to enable things like libraries, and it was to enable things like the printing press, because we wanted to expand the public domain. However, ironically, because of a law, again, in good old USA, that was introduced to counter slavery, where basically you had to acknowledge a person as a person and stuff. There was an amendment passed, I'm not going to say the number because I'm almost certainly going to get it wrong off the top of my head, that basically said a person is a person and you can't deny a person rights. And a whole bunch of merchant people took the concept of corporation, and I could do a whole nother video on this, and they were like, what if we got a corporation to be a person? And corporations initially, by the way, were very short-term contracts for a common group of people to get together and build a bridge, say, as a common example. Once they managed to identify a corporation as a person, then a lot of these laws, they were written and passed in courts. Because this is the other thing you've got to remember, right? The letter of the law is always faced, at least in most democracies, against a court or judicial system. And contrary to pop culture, court and judicial systems are generally very good at nuance. That's why they exist. So the classic thing is everyone's like, oh my god, the letter of the law says this. But genuinely, if a judge thinks something's reasonable or a jury thinks something's reasonable, you can make a case for it. And that's gonna hit us in a bunch of ways. And ultimately, most systems, including the US, including the UK, the highest courts are judicial, not jury based, right? So they come down to really understanding nuance quite well. But anyway, we are drifting. The reason I'm mentioning that is because a lot of these laws, we want strong protections for authors. We want strong protection for individuals, because when we see an inventor, when we see an author, when we see a creator ripped off by other people, we feel bad. We can very easily empathize with that person. And so there was quite strong person laws passed for copyright and IP protection, because everyone could understand, well, that's kind of shit. My stuff got ripped off. Cry and cry, cry, right? But then all of those rights got transferred to corporations using this loophole with in the American Constitution. Then it gets worse, right? Then basically what happened is, so for instance, Japan's remix on copyright, their old remix laws basically went something like this. If there is a painting, okay, and I cut the painting in two, and I shift the bottom bit of the painting a bit to the right, so it looks like this, and I publish it like that. I'm drastically simplifying here, by the way. That's a unique transformative work and is not protected by copyright, because what fool would confuse these two things, right? So Japan, for instance, had pretty lax laws on this. The cultural norms varied around the world, but mostly it started before the 80s, but the 80s was when we started getting a lot of movement on this. We started doing a lot of trade deals, because people were like, well, we're in a global economy, we need to unify our laws, because if we don't unify our laws, some countries are going to rip stuff off. And it's actually really funny. If you look at things like Italian Spider-Man and a lot of that, what that usually applied to was these kind of trade deals where, so now, for instance, under modern trade deals, if I patent something in the UK, it's patented in the US automatically, and it's patented in a lot of other jurisdictions automatically. Likewise with trademark and copyright. Whereas previously, a lot of these countries had individual systems, and in these individual systems, as part of registering your copyright or your trademark, the individual cultural norms applied, and there was usually a tax or a fee paid to the nation in question as well, or whatever administrative body ran it in that particular nation. However, mostly spearheaded by the US, trade deals came along. And we basically, the rest of the world got fucked, and we basically all got grandfathered in to this system where we acknowledged companies were people, and we acknowledged that IP laws could go on for a ridiculously long time, and we got into the land of long rule the mouse. The mouse is in the house. And that, the trade deals thing, particularly picks a lot of civil rights and a lot of intellectual property lawyers in certain jurisdictions get very upset by this, because it was never voted on, it was never agreed on, it was something that was agreed by trade deal and snuck into a lot of countries. So this is a huge issue, right? We have to go through all this background to explain, though. So where are we? That is where we are today. And what does this mean? This means that if an author or an artist, okay, makes a thing, for most countries, the copyright, for a lot of copyrights, it's automatic, by the way. So for instance, your photography copyright is automatic. You don't have to register it. There's others you do have to register. Character names and that kind of thing, you always have to register. But that author or artist, when they make it, the copyright is their lifetime plus, I think it's 20 years now. I'll have to check. Plus X years. Basically, fuck off long time. Just ridiculous long time. It's their lifetime plus X years, or I think 75 years, whichever is longest, not shortest. And this, combined with estate law, that's basically when I die, you get my shit, and corporate ownership, basically mean you can transfer this over, and there's a whole bunch of loopholes to keep shit alive in this. But the law and the legality here is 100% on the author / artist's side, and therefore 100% on the corporation's side, right? Now, trademark laws, they have to defend, and if a trademark is not actively defended, it can be lost. Do you know that Nintendo pushed in marketing the concept of a video game console and video games, because the Nintendo was being used as a reference to video games, and they didn't want to dilute their trademark, and they didn't want to become a Kleenex, where tissue paper can be legally referred to Kleenex and the trademark is not substantive. So all of the rights are with the artists. Now, because we never voted on this, and because there was no cultural change with this, and this all came about in trade deals, there were a lot of loopholes, right? Probably the biggest one is the remix tape, the cassette, right? You had also the issue of educational use, and a bunch of other edge cases that were, hold on, I need to put in the dodgiest of dodgy that no one understands, that pisses me off immensely, and we will get to it. Fair use. Oh, that is trouble. That right there is trouble. So, in different nations, it applies differently, right? Do not assume, even though I said earlier how trade laws basically unified copyright and IP ownership across the world, do not assume that it applies evenly, right? There are national exceptions, and these have mostly been fought out in a court case battle. The case of cassette remixing and mixtapes, this actually went to court, and this actually got fought, and VHS tapes similar got fought, and the protection here comes for non-commercial, non-distributive use. So for instance, if I in my own home am remixing music, and I am making VHS tapes for my own family and close friends, and there is no distribution involved, remix 100% covered, right? But you can already see how that's going to become a fucking huge problem with the internet, right? Because again, these laws, most of them are quite old, and most of them were jerry-rigged, and most of them were not written for the internet. Again, educational use, pretty much no one wanted to, again, this comes from court cases, no one wanted to take a teacher to court for showing something or using a copyrighted text in their classroom. So educational use in most jurisdictions is protected. However, there's some pretty fine limits around what educational use is, and if you're a teacher in front of a class of physical students and you're using stuff for educational use, you're pretty much solid, right? There's pretty few cases in which you're not solid. You, for instance, couldn't play them the entire Frozen, potentially, but you could play them clips from Frozen, wouldn't be a problem. Now, there are some issues here that come under the murky thing of fair use, and I also say satire. So basically, what is this big nebulous blob that everyone misunderstands? The short version is the work transformative? Now, what applies transformative is highly variable, and what most people on the internet says applies transformative is not transformative. Unless you can find a court case where something has been won, there is no clear definition on what is transformative. Transformative work, and satire especially, because people want to be able to satirize key work, especially when it's the protection for the stand-up comic basically came in, and additionally the protection for critical examination came in, but it didn't come in evenly, right? This was not something that was internationally agreed. And for instance, the US, ironically, despite saddling us with most of this bullshit, has some of the stronger fair use laws. The UK doesn't have very good fair use laws. It is very unevenly applied. And this is where the fan art argument starts creeping in, and this is where people get themselves in trouble. Because fair use was never broadly defined in these treaties. It was never sort of unified across areas. So unless you can find a court case that basically says your specific fair use applies, i.e. You're making a new show and you're using short clips, then that's okay, right? But yeah, fair use, huge tangle mess. So this is where we get to the point, with the transformative point, where people think, hey, my comic or my fan art, right, featuring Pokemon as people, or featuring I don't know, My Little Pony dragons, okay, is fine, right? First of all, the number one hurdle that most people hit, trademark. The moment you use a name, the moment you use a brand or anything like that, you hit trademark, you're fucked. That's just the nuclear option and you're screwed, okay? Just don't touch trademarks, okay? That's like rule 101. Don't touch trademarks in any way. But now we get into the tricky one of transformative work. Now again, I'll repeat this disclaimer from the start. I am not a lawyer. This is not legal advice. Blah, 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 blah. So remember how we were talking about that distribution thing? A lot of people got the remix laws confused with the fair use laws. As in, It's perfectly okay legally for me to have a bunch of home tapes and home comics where I've cut them up and I've remixed them for my own personal use, and I do not intend to distribute them, even in a non-commercial way. Right? It's not about commercial distribution. It's not about me making money. It's about not distributing them. It's about personal use. Okay? So I can take Godzilla and Spider-Man and I can make them gangbang, and I can draw it and I can show it to my friends on a piece of paper. That is fine. Right? Because it's personal, not going to be pursued. The moment I upload that to the internet is a distribution mechanism, right? And if it can be shown that I have used it as a method of distribution, for instance, if I Xerox, so this is why law is really complex, right? If I take that thing and I Xerox it, I photocopy it a few times, and I give it to a handful of my friends, if it is like less than 10 copies and we went to court, right, the judge would probably rule that I wasn't distributing it. It was personal use, right? He'd probably rule under that sort of line. If, however, I posted it onto Facebook and it got 2,000 likes, 3,000 likes, if it became the trending thing of the day and a million people saw it, there's a pretty clear-cut case, even if I didn't get those likes, because I theoretically could have got those many likes and that exposure. I have distributed this content. Okay. So that's where it gets tricky. Now, where this is clear-cut, as in there is no uncertainty at all, is Comic-Con, because this is where I come across this all the fucking time and it annoys me. You will have people selling fan art or transformative work of protected media, which I think, as I said at the start with my bias, they should be able to do, but legally they cannot at the moment. The problem is they are selling their Spider-Man, Godzilla slash fic at again at Comic-Con, and that is so clearly wrong, because not only have they crossed the distribution line, they have crossed the commercial line. Okay, but they get away with it because, unlike trademark, it doesn't have to be vigorously enforced. Okay. And remember how I said at the start of this, judges, so if a judge looks at it, she can see nuance. If a jury looks at it, they can see nuance, and they can apply cultural norms and cultural expectations, right? So if little Susie took her comic that she had made based on My Little Pony, and she was selling it, right? But it didn't use the trademark, right? So there was no trademark violation, because trademark laws are very clear cut. So it didn't use the words My Little Pony. It didn't use the words Godzilla or whatever. It purely resembles the work. Okay? And also character names are intellectual property or copyright. Character names usually aren't trademark unless they have been, you can always look up trademarks online, but unless they have been trademarked, they're so Sonic, for instance, is a trademark. But so if little Susie was in court and a jury looked at this situation, they probably, is Kratos trademark? Kratos is not trademarked because Kratos is mythical figure. There's particular usages of a character and myth that could in theory be. So for instance, Snow Queen, not trademarked because it's a fairy tale. Elsa, as a depiction of the Snow Queen, probably is trademarked. I'd have to look it up. But more loosely would also apply under copyright usage. However, in this situation, if this genuinely went to court, we don't know how it would rule. We don't. But given cultural understanding, given empathy to this ideal use case, right, the courts would probably rule in little Susie's favor, saying the work is transformative. Depends how transformative it is. Again, nuance and details apply. Now, if Susie is sitting next to a fat stack of $1 million and she is raking it in, the jury is probably going to be less interested, especially if she has 20 issues of this transformative fan art work that's all based on the same property. All right? Again, nuance would apply here. But companies don't want this court case to happen, right? So companies let fan art and a lot of loose transformative work at places like Comic-Con slide because they don't want to see this court case, because modern IP and copyright law has not gone through our judicial system and through our political systems. It has mostly been a trade agreement between nations, and a lot of nations, especially not United States, especially Europe, especially Asia, if these things went to a court, probably wouldn't land where the trade agreements land. Now there would be international versus national pressure, and there would be a whole bunch of situations that come up there. But for this reason, fan art, even though legally it is 100% not okay in most of the situations that people are seeing, under current definitions, slides, because companies don't want to take this to court. However, Little Susie was what we call an ideal test case, right? If a group of 30-something business people got together and made a small company, and they made mostly work based on other copyrights, and they were doing transformative work, that is a good test case for the corporations to test IP law. Or better yet, Article 13, which got renamed to Article 17. And I'm actually strongly in support of Article 13 for another talk I will give on platforms and IP ownership and editorial work. It's a whole nother issue. But I'm actually strongly in support of it. It's been misrepresented by corporations. But under all of this, if I can take YouTube to court, if I can take someone who isn't Little Susie to court, right? If I can take a company to court, the case will probably land in favor of the IP holder, because you don't have the nuance of an individual creator or a small creator against a bigger company. And again, I am not a lawyer, but I am stating the issues here. If you make a character, so yeah, visual representations of characters, this is why I'm describing fan art, are under current copyright laws mostly protected. So if I drew a character, so in chat they're asking about Kratos, and if someone made a character look like Kratos, and here's a very simple thing. Think to yourself, if I made a certain, I'm intentionally not drawing this well, by the way. If I made a certain mouse character appear in whatever story I was writing, never named that character, never named it, but used it visually, I'm no way protected. I am in no way protected. And that generally applies to characters. Interestingly enough, Harry Potter, the name, got into legal dispute when the first book was released because of a bad horror movie where there was a magical horror movie where the main character was called Harry Potter. So there was some dispute about whether or not that name could be protected. And it is protected. It's protected under certain use cases. But yeah, you can always look up what copyrights apply and what intellectual property apply. But generally speaking, if there is anything you've seen in a movie or a TV show or anything like that, I guarantee you the intellectual property lawyers have done their work and they have registered all of those bits and bobs. Now, one of the reasons we see so much Sherlock stuff, one of the reasons we see so much of that stuff is because Sherlock is not in copyright. They're in the public domain, so we can do a bunch of stuff with it. A particular representation of Sherlock could be copyrighted, but we have moved on it. So I strongly encourage people to follow the letter of the law, because at the moment companies get the best of both worlds. They get to have these ridiculous IP laws that are just stupid, absolutely stupid. Protect them when they need them. They get to shut down fans and works and derivative works when they need to, because legally the law is on their side. Unless you're willing to take this to court, the law's on their side. But then they get all the free promotion of all these people going to, say, a Comic-Con and selling transformative works, fan art work. And the problem is those at that same con, you've got a bunch of people selling original work that is struggling because it's not riding on the marketing coattails of Pokemon, right? Pokemon has had more money spent, or pretty much any intellectual property has had more money spent in marketing that property than ever there was spent in developing that property. And so by making derivative fan artworks, all you're doing is you're leeching off that marketing spend, which is why it's illegal in the first place. But then other people who are making genuinely original work aren't getting the attention. Good news, most Comic-Cons have started black bagging, especially here in the UK. There's a bunch of individuals who, I know some of them and I'm friends with some of them, they're actively calling the authorities to conventions, and they're getting the stands black bagged, they're getting merchandise confiscated, they're getting people fined for large things. Usually it's trademark, because trademark is clear cut. If you breach trademark, you breach trademark. Copyright's a bit more unclear, but it's gotten so bad people are actually just breaching trademark. So we are starting to see this black bag. It hasn't come to the internet yet. Physical venues is much more easy to prosecute. I would not be surprised, and I actively encourage it to come to the internet, because it's only by forcing this conflict that we will actually start to see progression on these on the legal front. Okay, there's a lot in there. Before we enter the recorded section, because there are some questions in chat, we are going to do a Q&A on this. So let's start from the top here. And again, legal disclaimer, right? This is not legal advice. And I will do a separate video about Article 13 and platforms at some point. As for IP patents, etc., yeah, it does get more tricky with patents and such. But it's actually, no, actually I disagree. I'd say copyright's a lot more tricky than patents. Patents are really clear cut, because patents protect literally what is in the patent. If you manage to, that's why patents language are so broad, because if you manage to do something that is slightly outside of the language of the patent does not apply. That's why language, if you ever read patents, and I've actually filed patents, like there's several patents in my name, the patent lawyers will go through and they'll expand it as much as they possibly can and get away with. I'd have to check Wikipedia to check the exact names, but as I say, it's lifetime plus X or some period of time, whichever is longest. It is literally this year is the first year we've had new works come into the public domain for quite some time. Next year, on January 1st, we will have a few more come into public domain. There is a list on Wikipedia. I highly encourage you to look at it. I highly encourage you to remix the stuff that has come into public domain. Also, there's a lot of authors who have just let their works lap into public domain. So it is good. We'd already discussed the issue of individual characters being trademarked. The biggest and easiest thing to do for yourself is ask, if I put a certain mouse in the same position, is it probably covered or not? And I think we all know the answer to that. And as I say, the parody exception. So we did cover the murkiness of remix and stuff earlier in the talk if you missed it, around fair use and stuff. Fair use is broadly misunderstood, doesn't apply the same to every country, and if you are putting something online, a company can choose what jurisdiction to bring you to bear in, and it will probably pick the jurisdiction that's not in your favor. And if it's an international company like YouTube that has the right to take it off, like there's no freedom of speech on YouTube, so to speak, they have the right to remove content. If there's any dispute, they will probably just remove it, because there's no reason for them to take that to court. So yeah, fair use is broadly misunderstood, unless you can find a court case that specifically defends your specific usage. I wouldn't consider it there. Music's not its own crazy world. Music is actually pretty much covered by all the stuff I've spoken about. There's some specific things around mechanical licensing and cover usage and stuff, because musical law, there's been more court cases basically, and there's been more unionization, and there's been more formation. But no, I mean, I'd say if you want to talk about crazy copyright, photos are probably one of the craziest copyrights, because a photo is automatically copyright at the moment you take it. It is the ownership of whoever took the photo, not necessarily whoever owns the camera and everything. There's been some crazy laws around timers and instigated photos. Photo photography is pretty crazy, especially because I can photo a thing and that version of that photo is copyrighted, but then there's some weird ass laws around photography of copyrighted symbols, and that very unevenly applies. So yeah, if you want to look at crazy copyright, check out photos. It's insane. Yes. No, Tat. Okay. I will very clearly state this, Tat. I don't think IP laws are fair. I think IP laws have got into a monstrous state, and I strongly support the public domain. However, because of that, I think the law should be strongly enforced, and I think people should be punished and curtailed by the letter of the law, because by bringing this to court and by aligning people's expectations with their cultural expectations with the letter of the law would be changed. Because I don't think the average person on the street would support the law as written at the moment. But they think the law is different, because everyone thinks fair use is broader than it is. Everyone thinks that remix culture is protected, and it's not. It's not protected. So if little Timmy got taken to court for making his t-shirt with a funny character on, then what would happen is we'd go, what the fuck, that's not right. But under the way the current law is, because they don't have to prosecute to protect their copyright like they do with trademark, right? And trademark law has generally been kept sane, and no one is in any confused state because of trademark law, because you legally have to pursue a trademark. And whenever you see these fan films and things get shut down, they're usually shut down by trademark laws because the company has to defend that. But for instance, there is no legal protection for Twitch. There is no legal protection for YouTube gaming videos. Under the letter of the law, those are actually potentially owned. However, there's a large enough body of work there that I'm fairly certain if that ever went to court, we would clearly walk that through. So that's a situation where common usage, because this is the other thing, is if a company lets something slide for long enough that it becomes common usage, the law will adapt to what is common usage, not what is actively written in the letter of the law, generally speaking. As I say, these things will come down to the judge in the court case and how the particular test case that's being used unfolds. Cease and desist, yeah, cease and desist. They're used pretty harshly, but yeah, the biggest issue is you've got two camps, right? You've got the fan art camp, and then you've got the OC camp, right? Now, the OC camp, they're doing things by the letter of the law. They're building out new IPs and new franchises, and these are new original people, and they have your average person who goes to a Comic-Con, your average fan film, whatever, spends anything from nothing to less than $1 million on marketing, right? Anything that is known enough to have fan art made of it, I guarantee you, has spent more than 10 million minimum, absolute minimum, on marketing. And so by making stuff in this nebulous area, you're benefiting from all of that positive association and all that marketing, but at the same time you're not building anything of value. And there's a whole nother argument I can make as to why it's bad for the artists themselves, because that portfolio of work, no good. Let's put it this way. If you're a writer, say, and you write one book a year for 30 years, at the end of that you will have 30 books that could be sold anyway, right? That's fan-fucking-tastic. Even if those books never sell a huge amount, that's 30 books you own that could be optioned into movies, that could be licensed, that exist as a thing. It is this capital, it is this inheritance. You have this thing that you have created that is protected under law. That's wonderful. If, however, you spend 10 of those 30 years or 20 of those 30 years writing fan fiction, it's useless. You can never do anything with it. You might, at limited small conventions, be able to sell some stuff, but you can never license it. You can never broadly distribute it. And at the drop of a hat, you could lose it all with a single cease and desist letter. You're fucked. So that is the artist argument as to why you shouldn't do fan art, because, yeah, you would be fucked. And as I say, at an event, the strong incentive for us to get these fan art tables shut down is because when a punter goes in there with 100 quid to spend, or 50 quid to spend, your average punter will spend the bulk of it on the second category, because it's what they know. And most people don't understand the difference between official merchandise and unofficial merchandise, especially when they see it at a place like Comic-Con and they assume it's official, because this is not some dodgy stall. This is this is very much applies. And yeah, so that's how I think we will get reform. Any other questions before we wrap up the recording on this, folks? Any other questions? So morning here. Okay, so with that, for those of you on YouTube, you can always join us live in the morning for chat on Twitch. But till then, ta-ta.